Okay, well, we're here today in the Capstone to discuss criminal law, and the course that you need for this that leads up to it is the course Para 211, and it is basically the equivalent to the Crim course 240. So, that's what we're going to run through really quick to try to make it where, you have a little bit of background for these tests. I know I'm running a little bit late and I apologize on some of these, but this is chapter 12 of your book. It's discussion board 11. We're getting down to the end and there's just a lot of stuff to do, grading and advising and things like that. So it's kind of eating into my time a little bit. Well, one of the things to understand is there's different jurisdictions. So jurisdiction is important. Basically, you should expect that a person will be tried for a crime where it happens. So in other words, the location of the crime is the primary factor in terms of deciding the jurisdiction. One of the things that you get into, though, is, and that's where you have bail jumpers and bail bondsmen and, dog the bounty hunter and all that kind of thing, is you'll have people that'll try to leave, escape, abscond, and so they try to bring them back into the jurisdiction. If it's a real serious crime, they're going to keep you in jail. Or if you can post bond for that crime, they're going to, put some pretty strict limitations on where you can go, like you can't go out of the country. This George Zimmerman's a good example. All of a sudden, early on in the case, he has tickets to Brazil, so that could have been interesting. And they said, you can't be going out of the country. Big thing important is that there's different courts in different parts of our government. Of course, the federal court has its own, jurisdiction, and they have certain federal crimes. And really, there's only really one federal crime mentioned in the Constitution, and that is treason. But there's been almost an explosion in federal crimes over the past few years since 1900. And that's just a more complex government. And so basically, and I'm going to put this one here, most of your cases that you see involving local issues are handled in either state or local courts. A lot of times a municipal court, like a city court or something like that, they handle, misdemeanors, and this is another issue about jurisdiction. This is what we call limited jurisdiction, okay? Now, one of the things that you need to understand is that the state courts have general jurisdiction, and the federal courts have federal jurisdiction, okay? And so basically what that means is, I'm just going to shorten that, is that in the federal courts, they only handle cases that are somehow connected to the federal government. But the actual federal government can call on the state to help them. So for example, if someone does get picked up on a federal warrant, they can be held in a state jail until they can be extradited over into the federal system. Same way between states, this whole thing of extradition. Extradition involves, and so they have to be in the jurisdiction where the crime occurred. The issue that you get involved in is, are you the person we're looking for, and is there probable cause you committed this crime? I had a case one time out of like Riverside, California, where the guy was being extradited, and I had to conduct an extradition hearing. And a lot of times guys will waive extradition because it helps move the process along. Because in the state where they find you, the state there cannot allow you to post bond. You're held in jail. The only state that's generally allowed to set bond is the home state, which is where the crime happened. So these are all different aspects of the concept of jurisdiction. Sometimes there can be concurrent jurisdiction, and that's what's going on right now with this Zimmerman case. Is the question, is there a concurrent jurisdiction here because of a civil rights violation, okay? But the question on that is, and this is why this is probably going to be difficult, but could happen, but I mean, chances are it won't, because there's no state actor. By definition, the issue with this Zimmerman was he was not a policeman. He had no authority really to approach this kid. And so it is probably not going to be a civil rights violation under federal jurisdiction, just as it was not a murder according to the jury in the state general jurisdiction. So there are instances, though, where the policeman beat up Rodney King in California. The jury found him not guilty. Federal court turned around, took him to court. They ended up sitting in federal prison for like 8 years. So those things can happen, and it is not a form of double jeopardy because it is two different sovereigns, is what we're saying. Is different theory for the crime, the federal civil rights violation, different than aggravated battery. That was the California statute. So that's how they can have concurrent jurisdiction and it not be a violation of double jeopardy. Well, moving on, there's different theories of crime as far as why does crime happen, how does crime happen, and what is a crime. And so a lot of times we've got to look at the sources. And sources of our criminal law come way back from our old forefathers, what we called the common law, okay? So there's certain things that we always knew to be wrong. Like murder's wrong, rape's wrong, kidnapping's wrong, stealing is wrong, So those are just basically what we call malum in se crimes. And that just means, in its essence, we know it's criminal. You're born knowing that it's not good to hurt somebody. As an early child, you're taught, no, don't hit your sister, things like that. The other type of place to look for crimes is in the Constitution. And in the Constitution, we're talking here about organic. And so this is where we get concepts like due process and this type thing. So there's, in addition to the malum in se type crimes, there's also a malum prohibitum, which is legislated crimes. So those are the crimes that tell us that drinking too much is a crime. Using drugs is a crime. Speeding is an infraction. And so all this structure of these crimes flows out of the organic law in the Constitution, and then a lot of the concepts like due process and creating legislative crimes are based upon that concept. Okay, so it's also important to keep in mind that the theories of punishment are important to consider. What we're looking at there, we've got deterrence, which is, in my opinion, a waste of time. No one is really ever deterred. The important thing on deterrence, there's two theories, what we call general, and that is where, Johnny gets caught robbing a liquor store and gets 50 years in prison. So all of his friends from high school say, well, I'm not going to rob a liquor store, and that is totally false. They don't think like that. And then the specific deterrence is, well, Johnny is being deterred for at least a while because he's sitting in prison. But that's also another concept called incapacitation. And what that means is, hey, and that's what's going on in America today. Just take these felons off the street and don't let them back on, and keep them there as long as you can. There's another aspect of that is called retribution. That's kind of the get even. And basically that's kind of like biblical, an eye for an eye, a tooth for a tooth. So that's another possibility as far as the reason why we punish people. There's a lot of different ones. There's the shaming, which is where they used to put the guys in the stocks on the town square, and they'd have to sit there and people throw fruit at them and tomatoes and stuff. And then the final one that we want to talk about is what we call rehabilitation. And this is the one that I think has the most hope for society. And really, what we're looking at here is a three-pronged attack on crime using rehabilitation. One is education, one is counseling, and one is training, okay? And what's the difference? Okay, well, this is, can you read? Okay, counseling. You got a substance abuse problem. I'll bet you 80% of the crimes that I've seen over the years all involve use of drugs, use of alcohol, somehow tied in. Either stealing in order to get money to buy drugs, or hey, I took drugs, got in a fight, hallucinating, beat somebody up, killed them, this type thing. And training is more like, you want to be a welder? We'll teach you how to be a welder, So you need all three of these. You need to be able to read and write and do some basic figuring and learn a few things like history and stuff like that to be a productive citizen. But also the counseling and training, very important. You can also have counseling for things like anger management. I've seen effective counseling, which is another myth, that you can't do anything with child molesters, but I have actually seen success in some cases where child molesters do learn their lesson and don't ever do it again. And it's like being an alcoholic. I mean, they're never cured, don't get me wrong, but it does, you can actually help them, which is, good for our kids. Another thing, we have crimes we call capital crimes. What that is, death penalty. There's a raging argument now as, should we even have the death penalty? There's been a lot of cases, over 300. Innocenceproject.org, www.innocenceproject.org. If you're interested in this at all, look it up. And it shows over 300 cases where innocent men were on death row. There's misdemeanors, and these are lesser crimes, usually the punishment under 1 year. So it's less than 1 year, let's put it like this. Okay? So what that means is that there's only, let's say, 6 months in jail, something like that. Felonies, on the other hand, are more serious crimes. They range from the lower level ones like theft, all the way up to like bank robbery and different crimes like that. So they're all, but they're not capital crimes. In fact, there's a case out there called Kennedy versus Louisiana. That says you can no longer give anybody the death penalty for anything except death. That's the law in the United States. So this guy was given the death penalty for child molesting and in Louisiana, and they said, no, you can't do that. Okay, moving on, we've got to hit a couple more quick points here. There's concepts called void for vagueness. What that means is if a statute is too vague, then you can't proceed with the cases. And that's happened actually in Indiana on the DUI law, you cannot file felony DUIs for a whole year because they messed up and it was ruled by the court to be void. Also, ex post facto means it's Latin, and it means you cannot go back and punish somebody for something that was legal before. So in other words, you cannot make a law that says it's a crime and make that retroactive. So no retroactive crimes, okay? And this is an issue that's come up with child molesters because they now have this registration law that they've got to register. And there's a big argument about whether you can make them register if they committed their crime more than 10 years ago or whatever it is. So, you know, that's going on. It's hard to say how that'll come out, but it is interesting. Bills of attainder, okay. Here's a little assignment for some extra credit points. Look this up. I'm going to let you look this up. It's a very rare situation. It's been illegal since the Constitution was created. Bills of attainder. So basically, this kind of is one of those things like the movie Minority Report. Check that out and then let me know, and you'll get 25 extra points for some of these. And I'm trying to send you a few points here, extra credit points, to make up the fact that I know some of these tests are kind of tough, and so we're going to try to help you make up for that. I'm trying to get along here. Okay. Basically, what we can also look at is some basic concepts in the criminal law. This is what we call the plain meaning rule, which means, generally speaking, whatever something says, that's what it means, which seems kind of simple, but there are times when it gets kind of complicated. Strict construction, that means, once again, the words mean what they say they mean, okay? So you don't expand on anything, especially in crimes. You know, you cannot go out further. Effect of repeal. And what that means is, you know, some people argue that if a crime is determined to be unconstitutional, then it has to be taken off the books. And if someone was sentenced to prison, then it's retroactive on that. Now, you can have retroactive new crimes, but if you find that an old crime was unconstitutional, then you really do have to go back and let people out of jail or out of prison that have been sentenced under those repealed laws. Now, it just depends on why the law was repealed. If it's repealed like, well, okay, that was all right in the past, but we're not going to do that anymore in the future, then those are not retroactive, okay? But if you're saying, well, we feel like this has been a mistake all along, then you would have a retroactive release of prisoners. And I was involved in that, actually, in Ohio when I lived over there. We had hundreds of people that released when they changed the drug laws in Ohio. Well, another important concept is this concept of merger. And basically, what we're saying is merger in some areas like attempt and solicitation, okay? They're saying is you cannot have that in the U.S. So the answer is no. There's no merger, okay? In other words, you can't go from a lesser offense to a greater offense. Basically, it's not double jeopardy where there can be multiple crimes within a certain fact scenario. Like, for instance, someone goes in, breaks in someone's house, that is a burglary, rapes the lady, and then steals her necklace. So what you have there, you have burglary, rape, and theft. And they're not merged together into one crime. They're all three separate crimes. They can be punished together or back to back. So we say consecutive sentencing. So a lot of times they don't do that because it's kind of overkill. people end up in prison for so long. But sometimes they do. I've seen where if someone's got a bad track record and they've been violent in the past, then that does happen. Well, we have to have the mens rea, which is the thought process to commit a crime, and the actus reus, okay? And so that is intent plus act plus concurrence. And what do we mean by that? Well, it means that this all has to happen at the same time to be a crime. Okay? So, a guy's a sleepwalker, let's say. I've seen that lately in a post that I read. No mens rea, doesn't know what he's doing. Awful tough to prove that defense, though, because who knows if you're sleepwalking or what you're doing. My brother was a real bad sleepwalker, so there's new rules that are coming out all the time. They're called model rules, model penal code. Not everybody agrees with them in all states, and so you don't get that. Like we were talking earlier about the UCC, all states adopted that. That's what makes it uniform law, but the model penal code is not uniform law. Some states have accepted parts of it, other states have not. I want to talk real quickly on transfer of intent. And now this is crazy, but it happens. Okay, what happens is this guy goes in to rob a store, okay? So the guy goes in, he's got this gun, he's holding it, now this is a gun, okay? And he's holding it on the clerk who's standing here, and there's a cash register, okay? And he's like, give me the money in the cash register. Well, he tries to shoot this guy, but it misses him and it hits the wall and it goes back and it hits this other guy back here and goes boom, 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 and kills this guy, okay? Well, it was not his intent to kill this guy. He didn't plan on killing this guy. This would be like innocent victim, this is clerk, and this is the defendant, okay? So defendant shoots at clerk, misses clerk, and kills victim, okay? Bystander, okay? Well, this guy's still guilty of murder because of the concept of transfer of intent. Even though he did not really intend to kill this guy, he shot at this guy, it hit a mirror or something and bounced off and hit this guy and killed him. And so I had a case like that one time in Canton, Ohio that we worked on. It was a gunfight at the OK Corral between these two drug dealers, and one of them shot at the other one and hit a stop sign, went off the stop sign and hit a passerby in a car and killed him. And they didn't find the guy for several hours. So, innocent victim shot in that case. Guy still was sent to prison for that, for murder, okay? All right. Liability of for acts of others. It's a conspiracy, remember, or accessory after the fact. Remember Dr. Mudd when John Wilkes Booth shot President Lincoln? He helped him out, and there's a question there. Guy comes in an emergency room, a doctor helps you. Is that an accessory after the fact, or is that just the doctor's responsibility to help everybody regardless? Well, there's more to that story. They found out 150 years later was he not only fixed the guy's leg that he broke when he jumped off the stage, but he also gave him a horse. And so by giving him a horse, he truly was an accessory to the crime. So maybe they got that right after all. And he was sent to the Dry Tortugas down by Key West and lived there, was finally pardoned 15 years later. But he was one of the very few that were in that group that was not hung. Even the woman that had the little boarding house was hung, and that was Mary Surratt. And there's a recent movie out on that about conspiracy to kill Lincoln. Insanity defense, this comes up a lot. Most of the time we see the McNaughton test, and that's like this. And that's a tough one because it's basic concepts of right and wrong. The thing you need to understand is, you know, people can be mentally ill but still know the difference between right and wrong, okay? The other thing I want you to know is that there's only about 1% of all criminals try to use the insanity defense. Many people have the mistaken idea that people are using this all the time, you know, that's not always true. Well, there's another defense that goes kind of hand in hand with insanity, and that is infancy. Infancy is, you know, a child is so young they can't form intent. They usually start delinquency at age 8, actually, in my experience. Your book says 7. And then children that are over 14 have been often tried as adults. One thing, though, is there is no death penalty for anyone under 18 under the current law. Exculpatory defenses are justifications, and that's basically self-defense. We know what that is, self-defense, or defense of another person. And it used to be that self-defense, you had to be backed into a corner. But now today, after we see what's happened with this George Zimmerman, with this stand your ground is one, which I don't agree with, because you can just be out anywhere and decide to shoot somebody and claim stand your ground. On the other hand, the castle defense, basically that's my home is my castle. I should be allowed to stay in my home in peace. And I do agree with that one. I mean, you should be able to have peace and quiet in your home. That's a time-honored tradition. It's thousands of years old, that nobody should come in your house without a warrant. And if someone is trying to burglarize your house, you should have every right to kill them. And I had a case like that where some kids had baled hay for a farmer, and they saw he hadn't paid them in cash, and so they made a stupid decision that they were going to rob this guy in his house because he had all this cash. Well, he just went to the bank and got cash to pay him when it was payday. He didn't have money laying around in his house. They're just stupid kids, you know. Well, they went in, they beat the guy up, looked around for money, didn't find any, stole a VCR and some jewelry and a few things, smacked the kids around, smacked the wife around. Well, by this time, the farmer woke up, and he went and got his little varmint gun, which is a .22 rifle, and he started shooting these guys, and he shot them all. He didn't kill them because the .22, but he was shooting them, and he shot them in the shoulder blades and the butt and all these different places like that, which would indicate they had their back turned to him. And so there was maybe an argument that could have been made in that case that you know, he was shooting these people in the back. That shouldn't be self-defense because they were running away from him. But kind of under that castle defense type philosophy that's very broadly accepted in the country today, they did consider that to be a justifiable use of force. And all the kids, when they caught him, actually got like 80 years in prison for that burglary, robbery, and aggravated battery because he knocked this guy out. Another crime I want to mention, necessity. Necessity is like, here's a perfect example. You're driving across Montana and you run out of gas and a snowstorm comes up and you walk up to this farmhouse and there's nobody home. So you bust a window, you go in, you throw wood in the fireplace, you start a fire, and you eat some canned goods like some pork and beans and maybe some Spam or something like that. Feed your family and leave a note and say, hey, I'll make this good as soon as I can get to town and get some gas and money out of the ATM and this type thing. Well, is that a crime? Well, no, because the necessity of the storm, I mean, you've got to take matters into your own hands and protect your family and do whatever you got to do. So necessity is allowed. Now, here's another example of necessity, though. Is it necessity that someone says, well, I wasted my welfare check on cigarettes and I've used up all my food stamps because I traded them for marijuana, so I'm going to go into Walmart and steal some diapers and some milk, maybe some baby food. What do you think? Well, that's not necessity, because you can go to the township trustee, you can go to the churches, you can go somewhere try to get some help, family members, there's all kind of other options. But a lot of times, small claims in city courts and stuff have taken kind of a relaxed view against young mothers that have done that when they catch them, and all they have is like diapers, baby food, maybe half gallon of milk. It's like 2-3 days before they get their food stamps. Another one is duress, and there's a great film out there with Harrison Ford, Firewall. In that film, basically he is a security officer at a bank. He's in charge of all the computers, and this other character has been in a lot of different movies. He's in, I think, some of those Brown movies where he's a bad guy. He's always a bad guy. But basically he puts the family, he's holding them and threatening to kill them if he doesn't get like several $1 million out of the bank. And so he works a deal where he's giving them the money, but then he figures out a way to take it back. And ends up, of course, killing all of them, because it is, after all, Harrison Ford. There's other ones that we could talk about: mistake, consent. In other words, you cannot be a victim of a crime if you consent to it. You say, well, yeah, you can have my TV, I don't watch it anymore, and then you can't turn around and change your mind. And sometimes, elderly people, especially on the verge of Alzheimer's, they get confused, and they're giving away their property because they think they're going to die or whatever, and then they forget that they gave it away and they claim somebody stole it. So there's situations like that that just be a mistake. Consent, mistake, kind of can be all wrapped up into one. You can have people that say, oh yeah, I like to be smacked around while I'm having sex, and so if you got some evidence of that, where someone's kind of masochistic, then that could be a defense to like a rape case. Entrapment is a very tough one to make. Entrapment involves people who are given the idea to commit a crime by the police. Important things to consider as far as there's two sets basically of offenses. Offenses against the person. I think you know what those are, starting with homicide, assault, battery. Mayhem is actually where you like cut their arm off. One thing I point out is that lesser crime, voluntary manslaughter, involuntary manslaughter, year and a day rule. You hit somebody real hard and they live but they're in a coma for a year and then they die for like a year and a day. Well, that has been modified by a lot of states. Modern statute, felony murder, that kind of goes back to the thing I was talking about earlier, where you go in, you don't intend to even use your gun, but it goes off. Maybe it's even in your pocket, and it goes off and you kill the clerk. So that's felony murder. You used to be able to get the death penalty for that. Some states have kind of backed off of that. Other ones, false imprisonment, different sex offenses, rape, statutory rape, incest, and obscenity. A lot of this obscenity is going away, but the child pornography has taken its place, and there's been a huge increase in crackdown on child pornography and different kinds of use of the internet to attack children in terms of sex. Well, the property offenses involve different kinds of larceny. In Indiana, we don't have larceny. We have what we call theft. It's unlawful taking of another person's property with intent to keep it from the other person, in other words, not return it. There is another one, it's a misdemeanor, which is conversion, and that is where you borrow property and you fail to return it. Others are robbery, forgery, extortion, receiving. One thing about receiving stolen property, if it is your intent to obtain property for the purpose of restoring it to the owner, that is not receiving stolen property. Offenses against dwelling, burglary, arson, vandalism. One thing about burglary is a complex crime, and why we say that is burglary has two parts, because it calls for you to first break and enter, okay, and then it is with intent to commit a felony, okay, and it can be any felony, okay. So it could be robbery, like the guys at the farmhouse. It could be rape. It could be arson. It could be, molesting. It could be vandalism. A lot of different things. Now, one thing that we get into is that if a person has consent to be in this house and then these other things happen after they have consent, then it is not a burglary. That's an important distinction. Now in Indiana they have a new crime they've put on the books called residential entry, and that is a D felony or lower felony, and that is people that maybe force their way in their girlfriend's house but have no intention of committing any crime. So it's the first part but not the second part. So that's why it's a lesser offense. Other involving perjury, subordination of perjury, which is asking somebody to commit perjury, bribery, the different kinds of crimes by employees or by people trying to influence employees of the government. Quickly, inchoate offenses, these are partial offenses. Inchoate crimes means partial, okay, or incomplete. And this would be your attempts, conspiracies that never come to fruition, and this type thing, okay? So inchoate crimes. Another thing to keep in mind is a modern concept called the RICO Act, RICO, and that's it has to do with mafia and drug cartels and things like that, but it has been expanded, used for a number of different things. It has to do with taking people's property. It's racketeering, corrupt influence, basically to commit a long series of crimes, like they may put people under duress and make them pay protection money, things like that. Well, one of the things is there are certain requirements under the Constitution. So, basically those are the 10 amendments to the Constitution. So, the different procedures have to follow and pass muster. So think of things like MAP, for example, or Miranda. And then that brings us to the next thing, which is the Exclusionary Rule. And that means the evidence can't be used if it's obtained illegally. So you violate Mrs. Mapp's rights to search her house, you find porn in her house, and you charge her with pornography, and you can't make it stick because you went in the house without a warrant. Now, one of the things to understand is there are exceptions to the exclusionary rule. There is such a thing as what we call harmless error. What they're basically saying on that is that a person would figure out, a policeman could figure out that a crime had been committed without the evidence. So it doesn't mean automatically that even if you leave the evidence out, that the case is going to be dismissed. Fourth Amendment, important, arrest, search and seizure. There are certain exceptions like searches incident to a lawful arrest, but when you get into that, there's a case called Knowles versus Iowa, where the guy is charged with speeding, and then they end up searching his car and they find marijuana. Well, the court said, no, you can't do that because speeding is not an arrestable offense. And so basically infraction, write them a ticket, send them on their way. You're not allowed to search somebody in that situation. But on the other hand, in the Terry case, Terry versus Ohio, the court said, yeah, that's okay because police officer always has a right to insist on his own safety, and so a lot of times they will do a pat-down search. If you find like a bulge in somebody's pants that feels like a gun, for example, then you can go further and search them completely, pull that gun out, find out what they're up to. Are they going to rob somebody? What's going on? So that is an exception to the exclusionary rule. Basically, pretrial detention, most people do have the right to bond. There is no right to bond for murder in the trial. You have the right to an attorney, a right to confront witnesses. These are all what we call due process. The burden of the proof is on the state. One of the big things that's another controversial issue is plea bargaining. People oftentimes want to say, well, plea bargaining is bad, but it does help the efficiency of the court system, helps to move cases. It can be bad for the prosecutor, it can be bad for the defendant, because sometimes people plead guilty because they don't want to get the death penalty, so that can be bad. There are sentencing guidelines. People always have the right to appeal. If you exhaust all your appeals, then you can invoke the habeas corpus, meaning you can appeal to the federal court. Prisoners have some basic generic rights, but they are not there aren't very many, mainly just the 8th Amendment, cruel and unusual punishment. One thing I would say, though, is that the ADA law, Americans with Disabilities Act, it does affect prisoners, amazingly. And so if someone is a handicapped or disabled person and is in prison, then they have the right to ADA, which means they have to have an elevator for them, or at least they have to put them in a place where they don't have to climb stairs, and many things like that you see for ADA for people out walking around, let alone in a prison. If they need a wheelchair, they get a wheelchair, just different things like that. Double jeopardy, always important. And once again, though, we don't want to get confused and consider something double jeopardy. Lastly, we have the onset of juvenile law, and juvenile law has changed since the 1960s. Basically, what we're looking at here is, there is a right to an attorney, so you have the same basic due process rights. No jury, though. No jury in juvenile court. One thing that you do want to know, though, is what we call waiver or bind over. That is one of those where very young kids, 14, 15 years old, are being tried as adults. There's a lot of controversy on that right now because it just doesn't seem to be working that well. And what you really do, you take a kid that maybe has committed a really heinous crime, but you put them in the adult system where they're victimized by other criminals, and so that's really no help to them. It's really no help to anybody. So some states have taken a really hardcore approach to kids in juvenile court. Places like Florida, the results have not been that good in regard to recidivism rates, reoffending of any kind. Usually you're just making better criminals out of them. Basically those are the important points for this. Hope you got something out of it. Good luck on taking your final that's going to be coming up soon. All right, well, that's it for this time. We'll be back later with some more.